It's Phil Ratcliffe, and thanks for joining us again on a beautiful Friday. Hope you're having some great weather. Today we've got John Weaver with us from Stansbury Weaver. Thanks for coming, John.
Sure, of course.
Appreciate having you in there. Before we get started, he's helped us with a lot of legal stuff, so we got to do our disclaimer and tell you we're going to give you a lot of great information, but nothing here is, specific legal advice to you. If you have specific questions about your situation, you need to contact John or your attorney and get that specific advice. So, John, tell us a little bit about you, how you got into law and specifically into IP, intellectual property.
Sure. Well, I grew up here in Columbus and went to Ohio State, was an education major, went out and taught for a couple years. Realized almost immediately that it wasn't going to work for me. Schedule didn't work, a lot of early mornings for teachers.
Yeah.
Grew up in a family of lawyers and just kind of said, well, if I'm thinking about doing something, I might as well go to law school and I can kind of figure it out from there.
Sure.
So I went and did that, did a whole bunch of everything when I got out of law school, a little criminal defense work, family law, stuff like that.
Yeah.
Ended up meeting my partner, Mark Stansbury, and we needed someone who could handle intellectual property. We work with a lot of startup companies, a lot of small businesses. So there was a need there for his existing client base. And
so you liked working together, and that's what you needed. And
exactly.
So
yeah,
that's how you got there.
It was sort of a thing where I came in, we saw what our clients needed, and I said, all right, I'll figure this out. And a few years later, here we are.
That's interesting, too, because I know a lot of attorneys, and I don't know a ton that do intellectual property type work. So
yeah, it's the traditional career path with intellectual property, I think, is to end up at a larger firm or in-house
or go
somewhere.
work for the government, right?
Yeah, or go work at the patent office, things like that. So there aren't a lot of attorneys, I think, that do it for smaller businesses, especially somewhere like Columbus, where the legal market's a little smaller.
Sure.
But it's great and it's really interesting. And I
Columbus is weird. I know a lot of people from Cincinnati and Cleveland, and it seems like all the professional services are bigger up there and down there than they are here, even though we're the biggest now, So.
Well, I think we only passed them in the last 5-6 years of growth as Cleveland's gotten a little smaller too.
Sure. So it's kind of like this. We're going up, they're going down.
Yep.
So what is intellectual property for those of our viewers that are just like, I'm kind of interested in copyright, but they don't really understand the expanse of it all?
So intellectual property is a term for a really broad area of the law that deals with intangible things. So when you think about property, usually you have real property, which is land, buildings, things like that. You have personal property, which is,
so it's easy to know who owns it, right?
Exactly. It's real easy to say.
I bought it, I paid for it, I got a deed, I got a title.
Real property is some of the oldest law that we have. It dates back to the Middle Ages, a lot of the rules and things like that. And anyone who's ever bought a house or anything like that, they know, going down and doing a title search, it's just all paperwork and it's real clear title and things like that.
Sure.
Personal property is the stuff you have. If you're wearing that shirt, it's a pretty good guess that's your shirt.
I didn't lease it.
Yeah. Well, I mean, you never know. Uber, but for leasing shirts, right?
Sure. Yeah.
And then intellectual property is sort of everything that's not in one of those two categories. So when you're dealing with things like software, right, that all falls under intellectual property. Whether it's the lines of code or the actual tangible copies on compact discs, like we used to do. Artistic expression, movies, music, art, that all falls under intellectual property. Ideas, the ownership of ideas is sort of this big frontier in the law.
Yeah.
And as we move into a tech-based economy, intellectual property becomes more and more important.
And then there's different intricacies, too, in terms of sometimes they say you can't own the actual thing, but you can own the process or whatever the case. And different countries define that differently as well, too, right?
Yeah, every country has its own intellectual property laws, although that's started to become standardized.
That's good,
Yeah, so it's definitely, it's a confusing area of the law, and a lot of the building blocks are based on real property and personal property. So it's trying to fit these pegs that don't necessarily fit into these concepts that we have, and it can get really confusing and really murky. And so that's why people like me exist, to help people out with that.
So what's the difference between the different types of intellectual property when we think about, I think most people, when they're reading on the web or they open that first cover of the book, they see copyright, but what other things are there, like the trademarks and what so?
So intellectual property, you kind of have 4 big categories.
Okay.
Copyright, which is, in a nutshell, the creative expression of ideas. So music, movies, art, that all falls under copyright, but also things like software code, which is where things get confusing. Then you have trademarks, which are things that identify the source of goods and services. So the Rebel Financial logo, Nike swoosh.
You did that for us.
Hey, there you go. Nike swoosh, the Apple logo, even the name Apple. Those are all trademarks, and they help people trust that the thing that they are buying comes from a certain source.
Absolutely.
Then a third area is patents. Patents is protection for inventions, basically. It gets a lot more complicated than that. Patent law is really, really exciting. But it's basically the idea that the person who invents something should be the only person who can profit off of that.
At least for a certain time
For a certain period of time, exactly. And then you have this fourth area that's sort of coming to the forefront now called trade secrets. And these are the things that are unique to a business and give that business an advantage and allow you to have protections there. So that's things like the secret formula for Coca-Cola.
Okay.
Colonel Sanders, 11.
You almost think that would be like a copyright, though, but yeah.
Yeah, but again, copyright law kind of stems from...
a patent. It's like a mixture, I guess, right?
Yeah. So one of the big differences between all of these is for trademarks, copyrights, and patents, you have to disclose what it is that you're protecting. So if you wanted to get a patent for the secret formula to Coke,
you'd have to tell everybody what it is.
You'd have to say, okay, patent office, here's the list, here's the recipe. And then if you could get a patent, it would only last so long. But if you protect it and keep it secret, then you can get trade secret protection, which is a really cool new arsenal that business owners have.
So that brings up a good point then to think about how would the government know that that's protected if they don't know what it is,
Yeah, and that's what's interesting about trade secrets. So trade secret until 2016 was sort of this patchwork. Every state had its own law. But basically the idea was if you treated something as a trade secret, it qualified for trade secret protection. So Did you password protect the files? Did you make sure not everyone could access it? But the only way that would come out is in litigation, basically.
Sure.
As opposed to a patent or a trademark where you can point to a sheet of paper and
Yeah.
say, hey, I own that, don't use it.
Yeah.
But in 2016, it was federalized. Federal legislation called the Defend Trade Secrets Act was passed.
It's recent. Yeah.
And so we're still unpacking all of the things that are in that law. It'll be a few years before we really understand the full protection that it has, but it has made things a lot easier for people who don't want to tell people what their secrets are,
Sure,
but want to have that protection.
It is interesting to me because another company that we're starting, Singularity Financial, one of the things that I personally believe is that that ownership of things is going to get more and more and more concentrated. And it seems like intellectual property rights have extended and extended and extended, and we're getting to where a very small few people own almost everything. And if you look at automation, if most people can't do work better than machines or computers, now they can't even work for money, and they don't even own anything. Where does that leave us as a society? I don't know if you guys think about that. But obviously you're trying to protect the interests of the people that are your clients, right. And of course the most people that can pay are probably the wealthier ones. But you're probably in a unique situation to where you don't work for the big rich company, you work for individual, probably upper middle class business owners and what so. Oh. But still, we're still part of not the top percent of people or what so. You know.
Yeah. I say this a lot to clients, but when you're in an intellectual property fight, when you're in litigation, it's usually less important who's right than who has the money, because to a lot of times enforcing these rights costs a ton of money.
Yeah.
So if you have a business and it has a name that you like and you've used it for years, and all of a sudden Apple knocks on your door and says, "You can't use that name. We use that name." A lot of times it's much cheaper to rebrand your business than it is to fight. I think you're right. That's a disturbing trend, and a lot of that comes from the fact that our framework of laws is really slow to change. As tech changes, as intellectual property becomes more and more important, we haven't seen a corresponding change to copyright law, to trademark law, to patent law. There are little changes, but...
It seems like if you want to have a meritocracy, then you should shorten the length of period, not lengthen it. But of course, if you own it, you want it lengthened. If you're the family, you want it lengthened or what so. But obviously, we need to protect people's discoveries and benefits from having worked hard to get something. But on the flip side, I guess you got to think about society as well too, and you want to maintain a meritocracy to where new people can come up and develop things too. Not that everything has already been protected and it goes down to the third generation,
right? Well,
or whatever the case.
And that's what you see with patent trolls and things like that, where sometimes it's just getting that patent filed, even though it's not something you're using, and then years later someone develops something, creates something, invents something. Now all of a sudden you've got a patent troll coming in saying, actually, I have a patent that you're violating, and you have to pay me off for that. And it is stifling innovation to some extent. Yeah, and it's a problem.
Yeah, you got to balance. I think everything has that. So, for maybe some of our viewers that haven't gotten into it, maybe starting their own businesses, maybe have a successful business, but they haven't thought about this, why is, protecting that intellectual property important? Besides the fact that you said if a big company comes in and wants to, well, still.
Right. Well, so a lot of the value in a company, when you start a company, when you grow a company, as you build it, a lot of that value is something we call goodwill. Sure. Which is sort of in accounting terms, this intangible thing that represents value. So whether that's customer loyalty, name recognition, things like that. So that's the accounting side of it, the business side of it. You want to develop that. You want to build a brand. You want to get a good reputation. You want your clients to identify you with certain values. Yes. The legal side of that is how do you protect that? And that's where intellectual property law comes in. It's getting trademarks for your logos and your business name. It's making sure you have copyrights on all of your materials that you're handing out and things like that. So making sure that you've taken the steps to register and protect those as necessary then puts you in a stronger position, when you're selling your business or when someone's trying to hone in on your territory. If someone, set up shop next door to you as Rebel Planning Services, well, that's going to immediately, they're hoping to piggyback on all the hard work you've put into building a brand. Sure. So without a registered trademark in that example, you can't enforce. It's tough to enforce it. You have certain rights that just arise out of using the name, but the federal registration really gives you a stronger way to get in there immediately, ask them to cease and desist, and then if they don't, it gives you stronger remedies if they ignore you. Yeah. So and you document your time frame of when you started and everything like that. Yep. And you, your attorney, and the government has looked and researched to validate that formally. Exactly. Right? Yeah. And so building up your intellectual property portfolio, I think it's best for business owners to think of that as though it is a tangible asset. Think of it just like it's your inventory. It's this thing that's on your balance sheet, and it's there for you to show to prospective acquisitions, people that want to acquire you. It's there for you to know that you've got protection if you ever need it. And by building it, you're building the value of your company. So what about copyright? Because I think it's confusing out there, even if you just try to look it up. And everybody puts copyright on their websites and stuff but isn't there something that, because you wrote it, it's almost like automatically your property? Yep. But when, again, you can't give specific advice, but when generally should you formally copyright it versus using the, it's almost taken for granted that it's your individual work. So I'll get there. Let me start. Okay, so we'll take a step back. With all these areas of intellectual property, it's all about consulting with your team, with your advisors, with your attorney, and figuring out what kind of protection do we want, when and how do we want to register it, and when and how do we want to enforce it. Yeah. So looking just at copyright, as soon as you create something that's eligible for copyright protection, you automatically, as the author, own the copyright to it. Okay. The little C in the circle, the registration symbol, you can put that on there as soon as you do it. If you write a piece of Harry Potter fan fiction, it's a bad example because that gets complicated. But if you write a book, that's copyright to you as soon as you create it and as soon as you publish it. Right. So not necessarily going through a publisher and that thing, but if you just posted it on your website, that's considered publishing. You have that copyright. You made it public so that people know. You made it public, exactly. Now, to enforce it, if someone then copied it and was printing it out and distributing it to people and you wanted to stop them, then you'd have to go and register it with the Copyright Office. And that's sort of a so it's basically them validating, saying, yes, you did put it out that early. It was before this person's. Now you can enforce. Yeah. And it gets a little complicated with copyright law. And it's really interesting because you get into some of these cases where, there was just a big copyright case with Wu-Tang Clan. And so, reading that and reading the briefings and it's, it's referring to the Wu-Tang Clan and all the members. It can be really interesting and fun to kind of dive into that. But the basic idea is, if you're pushing content out there, make sure you see how that fits in with your general IP strategy and your portfolio. And if enforcement you think is going to be an issue, you may want to go out and register it as soon as you publish it, as opposed to waiting for someone to infringe on it. It all depends on what you're doing, what the medium is, and what the enforcement strategy is.
Gotcha.
So, if you're going out and you're spending $100 million to create a movie, and you want to push it out on the big screen, you're probably going to register that copyright immediately, so that you don't have to wait.
What you got to pay for that is small compared to the gains.
Right. Right. But if you're a small business owner and you're doing blog posts every day, it's not worth a few $100 to register those with the Copyright Office. So it's all about understanding what the different mechanisms are, and then figuring out how that fits in with your enforcement strategy.
Gotcha. Okay. So let's think about when should a business or a person know I know it's not going to be perfect, but when should someone, it's like a keyword or a milestone that they're like, I should think about, my business is good enough that I should probably trademark what I've done.
Sure.
Or what so?
So I guess, as a lawyer speaking, immediately, right?
Sure.
I always want people to spend their first dollar on getting legal in there. But owning a business is all about risk tolerance. It's all about allocating your resources.
Yes.
So when you as a business owner are sitting down and you're saying, I've got, I don't need every penny now for operations. I can start looking bigger picture. That's definitely a good time to start thinking about it. Ideally, we do it right from the start.
Okay.
But that's not always an option. People have a limited budget when they're starting a business. I like to, as a general rule of thumb, when you're getting into things like branding, content, logos, things like that.
You feel like you have a brand.
Yeah, that's definitely a good time to
You're not just putting a
protect
shingle
it.
out and selling stuff.
Yeah. I also think before you invest money in it.
Yeah.
So if you're going to go out and hire a marketing agency and they're going to develop a logo and a name and they're going to push all this out and you're going to spend $10,000, on your brand strategy and that stuff, I think it's worth it to spend a little bit of that money on making sure you can get a trademark for it.
Sure.
Because if you go out and
you're not encroaching on somebody else's stuff.
Yeah. And that's that's the other big issue is if you spend all this money and you go live on your website, knock, 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 you get a cease and desist letter. Hey, I've got a registered trademark that's almost identical to that. You can't use it. Now you've got a sunk cost.
Yeah.
And so then the question is, do I throw even more money after it because I've already spent the money developing the brand, or do I go back and start from scratch?
Yeah.
So for trademarks specifically, I'd love if people could do it right at the start. Hey, here's the name I'm thinking of. Can we do a trademark search? Can we get it trademarked? But realistically, before you sink money into it.
Sure. And that's a horrible feeling to think that you build up a brand and you love your company as a business owner to think about, I have to change it.
Yeah.
Yeah.
And there's a lot of emotional investment there.
Yeah.
You're as a small business owner, as an entrepreneur, you're living and breathing with that thing every day. That is your baby. And so for someone to come in and say, you have to change your baby's name, that's not easy.
That's a good analogy. So what's the process? Obviously I've been through this with you, but if everything kind of went right, what's the process to say someone trademarking something?
So, a trademark usually starts with a consultation with an attorney. We sit down, we talk about your business, we see what the mark is that you want to protect, whether it's a logo or a word, a slogan, whether it's a combination of the two. Sitting down and identifying what are the things that we want to trademark. That's always the first step. A lot of times people come to me and they say, well, here's my business name, and here's a slogan, and I use a shorter version of the business name, I use all these things. So I guess I need 10 trademarks. And I'm going, well, okay, I'll gladly do that for you, but really you need 2 trademarks.
Sure.
And figuring out, what's the broadest protection that we can get you for the least amount of money.
Yeah.
In a perfect world, we're talking about a huge company with all these products, we're going to trademark everything and build this huge portfolio. But in the real world, we need to identify the key things that you absolutely could not live without, identify them, and then get that started. The application process, it usually takes between 6 months to a year to actually get registration of a trademark. But the good news is once you file the application, once the registration is granted, it's backdated to the date of the application. So the sooner you get it started, the sooner your protection starts. And once you get the application in, that's when it's usually considered safe to start sending cease and desist letters to people that you think are encroaching.
Hopefully you don't have to. But yeah.
Ideally you wouldn't have to, but we live in a world where it happens.
Another one that sticks out in my mind the most is, because I like the company like Tesla, I would say, is like they wanted it to be Model S and then E and then X. You get it, right? But I think I can't remember off the top of my head, but it might have been Ford owned the Model X.
Yeah.
And so they ran into that, and then they couldn't come to any kind of agreement, and then that's how the Model 3
There you go.
it came around.
There you go.
So again, obviously everybody's going to be different, and there's different cost of living in different cities or what so, but say that example what we were looking at, what's the range of expense that somebody be looking at? What's the government charge to file?
Well, that's the easy one to answer.
Yeah.
So there are 3 different kinds of trademark applications. The fees are, and these may not be completely correct, you can always go to the Patent and Trademark Office website and see them, but it's around $300. I think $275 is the class that I like to file. I think there's
a lot less
$350
than most people would think.
Yeah, that's just for the application.
Sure.
There's going to be legal fees on top of that, and that's going to vary case by case.
Depending on how complicated.
Depending on how complicated, depending on where the firm is located, how big the firm is. I've talked to people who spent $10,000 on one trademark application, which to me seems criminal, but it happens, and I don't know all the details. It could have been a very complicated case. I think realistically, people should expect to spend somewhere between $1,000 and $5,000 on a trademark application. So it's not a small outlay.
Sure.
But that should include the application fees as well as some sort of trademark search. We can all go on Google and try to find out what's out there, but there are companies out there that do it much better than we do, that use algorithms that know what they're looking for. And I think that's a really good place to start.
When you can be just U.S. or international or whatever the case,
yeah, you can do, there's all sorts of treaties and conventions and protocols that are out there.
I know when we've done stuff, then I think half of this is fraudulent stuff, but we get all these international mailings.
Oh, those are all fraudulent. Yeah.
Trying to get us to wire money to get ours, in Sweden and Norway as well as the United States, and it's just shred.
And that's, that's, I talk to a lot of people who have either done the application themselves or are thinking about doing it themselves, and there's nothing that I do in a trademark application that a guy on the street can't do. If you know how to fill out a form on the internet, you can file for a trademark. The value that a lawyer would bring to the table is knowing what the process looks like, knowing what to look out for in terms of obstacles.
Sure.
You can shape that initial application in a way that will smooth the process of getting through the trademark office, and get rid of some of the hurdles you might otherwise face. A lawyer is also going to be able to say, hey, ignore every email you get after we file this that talks about the application, because the trademark office is only going to communicate with the lawyer.
Sure.
So if you get something, it's from somebody who has set up some sort of web crawling bot that's pulling your contact info off your application and is just spamming you with emails from these companies that want you to buy whatever service they're selling.
Yeah. And that's, obviously, if it's just plain vanilla and you got something crazy unique, then it's just going to be easy. You just file a form, you pay that. But I had to say, I feel like I've been kind of unlucky because it's like almost everyone that I've done with you, there's been some kind of conflict. And one of them, we've just been sitting in queue for 3 years.
Yeah. Well, and that, that's sort of a technical detail. But a lot of times you get in line with your trademark application, and the trademark office won't even look at it until similar ones that are in line ahead of you get resolved. And sometimes these applications can take 5 years, especially if it's someone applies and they say, we're not using this trademark yet, but we plan on using it. Well, they get up to 5 years to sit in line. And if they go to market in those 5 years, they'll get the mark and you won't. But the trademark office won't tell you until they have a definitive answer. So it can get just really, really complicated. And that's why I like doing that trademark search. Because that'll show you that.
And if you're straight up front, you could just rebrand for almost no cost.
Exactly. Yeah. Before you've sunk any money into your branding, if you look at that search result and say, oh, I'm not going to be able to get this trademark, and then I'm not going to be able to protect it, well, then maybe it's not worth stinking, $100,000 worth of targeted ads and marketing budget and stuff like that.
So what would you say is probably the most important thing for people that are considering whether or not they need to do this, or maybe they don't even know that they need to do it?
I think that last part is really it. It's to be thinking about these things. A lot of times when you're starting a business, when you're running a business, when you're in the weeds of day-to-day operations, and are we going to make payroll this month, all that stuff, it's tough to take a step back and think about your business as a whole. But the more people are aware at a very early stage of what intellectual property is and how to protect it, the better off they'll be in the long run, especially if you're in the tech field. I think that's an area where, people don't realize, oh, I needed to have a contract with the developer so that I owned the copyright on the software code and he didn't own it. And by the time you've spun up your business and you've got an app in the App Store, well, all of a sudden you've got this developer saying, great, where's my half of the profit? Because we both own the copyright.
Royalty or something.
Yeah. So it's something just to think about, to educate yourself about. And for some companies, you know what? It's not worth sinking the money into it.
Sure. So if you did it early, it's probably going to save you heartache and money.
That's the big key there. You know, even just knowing what the risks are, knowing what your strategy is, you may say, you know what, it's not worth doing it. And I know if someone makes a stink down the line, if there's an issue, I'm just going to rebrand, and that's fine.
Yeah.
That might be the right call for your business. It's just you have to educate yourself. You have to talk with people that know the field, so that you can make those calls as a business owner.
Yeah. Okay. Well, good deal. How can people contact you if they want to get a hold of you?
Sure. Well, you can always check out our website here, which is stansburyweaver.com. Spelling's right there. I'm not going to try to spell it out.
And I think we put up your contact information on the bottom as well, too.
Our phone number is 614-489-9328. We're always happy to talk with people that have questions, that are not sure what they need. We'd rather people reached out to us and we could say, hey, you're fine, don't worry about it, rather than letting people kind of live in the dark and not know what's out there.
Sure. Well, we appreciate you coming in today, everything you've done for us personally as well, too. You've helped us with multiple of our companies and trademarks, and it's good to get that under the belt. So thank you guys for joining in, spending part of your day with us. We hope this helps you protect the great things that you're out there creating. Join us next week. We have Molly Schultz in here from Canine Companions. It's going to be a great thing. Maybe she'll bring a canine or what's on. Of course, we can have our own Allie in here as well, too. And then the week after that, we have Jill Jess from Mid-Ohio Food Bank going to tell us a little bit about the great things that they do and how you guys can help. So have a super weekend. And, of course, let us, John, know if there's any way that we can help you. And we'll see you next week.